My lord,
Sorry,
my lord,
some administrative work to be done. Yes,
my lord, I am seeking leave to file a public interest litigation by the father of the victim of a ST girl, my lord. There was a brutal murder.
why you need a leave? You can go and file it.
My lord,
It's a
there is a
public interest
grave
litigation.
urgency in this matter, my lord. The place of occurrence has been destroyed, my lord. The police is not,
Go and file short notice.
my lord, may it appear on Tuesday, my lord.
Yes, yes. Go and file.
Leave them.
Hey, short notice दिए दाओ.
May we permit it, my lord, to prefer an appeal
Leave to file the PIL with short notice.
or against an order, my lord, passed in 12th of August. May I be, my lord, permitted to prefer an appeal, my lord, without the certified copy. I've already
Sorry,
applied for
hey,
this.
no,
Sorry.
where is the gentleman? Where he has gone? Call him, call him. Call him.
My
Sorry, this is not a bench. We will grant you a leave, but come at 1. Come at 1. Yes.
My lord, without this certified copy, my lord, the order is passed in 12th of August. My lord, I have applied for the certified copy. My lord, may I just prefer leaving? Grateful.
May I have the kind leave of my Lord Justice Vishas to mention before my Lord Justice Tandon? My Lord has a bench at 1 p.m. with
Yes.
my Lord Justice Bhattacharya.
Yes.
Yesterday, leave was granted, my Lord, sitting in that bench for a public interest litigation that appears in item number 1. So, if my Lord,
We will sit together. That is a bench.
my Lord,
We'll
if
sit. Don't worry.
grateful, my Lord.
May I have your lordship kind leave to mention with regard to item number 68? Would your lordship be
6.
68 lordship review application lordship? Your lordship was pleased to direct that the matter would be taken up on Tuesday. Now it is be taken up serially.
If it is reached, just
Lordship,
remind us.
Maybe please to fix the matter on next Tuesday, lordship.
Please, when we have already directed, let the matter be called. Just remind us. We'll fix it. Don't worry.
I'm grateful to your lordship.
Let's call the list.
Item number 1.
But I am appearing on behalf of respondent number 1 to 6, 10 and 11, my lord.
The order suffers from illegality, infirmity, and in contravention to the law laid down in this regard, and therefore cannot be sustained. The order impugned is thus set aside. The appeal is allowed. Consequent thereupon, the application for probate is allowed. Probate court is directed to issue a probate to the appellant after filing fulfilling all other formalities required in this regard within 4 weeks from the date of the communication of this judgment. Let the LCR arrive to this court be sent down through special messenger at the cost of the appellant, which shall be put in within a week from date.
May I be permitted to see the judgment, my lord?
Obviously, that's your right.
No. Item number 2.
I am for the respondent writ petitioner.
I am for the appellants.
We thus do not find any infirmity or illegality in the order. Appeal is dismissed.
Grateful.
Item 3.
We thus modify the ultimate order to the extent that the respondent number 1, instead of being reinstated into a contractual position, may approach the arbitral tribunal for claim of compensation. So far as the refund of security deposits and letter of termination having found bad in law is concerned, same is affirmed. So also the setting aside the decision of the appellate authority in debarring the respondent number 1 from participating in future tender for 2 years.
Item 4.
I'm for the writ petitioner respondent, my lord.
I'm for the appellant.
Appeal is dismissed.
Grateful, my lord.
May I pray for the stay of the operation of the order?
Item
After
5.
the judgment is delivered, after the judgment is delivered in open court, the counsel for the appellant prays for a stay of the operation of the impugned order. Stop. We do not find any ground justifying the stay of the operation of the order, as we have affirmed the order of the trial court and dismissed the appeal. Stop. The prayer for stay of the operation of the order is hereby refused. What are you praying for? Only affirmation. Order. That brings 30 days petition down. Instead of 90, now you will get only 60 days limit.
Great.
Item 5.
I'm for the appellant.
We therefore that the balance is required to be established for the ends of justice, not to quash and set aside the appointment of the respondent number 4, which otherwise is inevitable conclusion in view of the discussions made in herein above. We therefore direct the respondent authorities to promote the appellant to the court of my assistant officer. We are conscious of the fact that the appellant was entitled to promote from the day when the respondent number 4 was appointed, and if his appointment is to be reckoned from a day when the subsequent vacancy has arisen, that is September 23, he shall be deprived of the seniority in the said cadre. We therefore direct the authorities that the appointment of the appellant to the post of assistant professor We therefore modify the impugned order to the extent that instead of submitting the views reported and audited by the board as well as the issue can be referred to a committee consisting of one member to be nominated by the board having a proficiency in the subject in relation to the questions over which the dispute has been raised. One member from the University of Calcutta in relevant subject, and one member to be nominated by the Vice Chancellor of the Visabharati University having knowledge expertise in a particular subject. We are conscious that there may be a multiple committee as a dispute has been raised on several questions and the answer is given for it. But in our opinion, it would bring a quitus to an issue and percolate a sense of fairness and transparency. The nominations shall be completed within fortnights from the date of the communication ordered by the respective authorities. The state shall provide all logistics to the committee members and shall also pay an adequate remuneration on honorarium as may be fixed. With these observations, the appeals are disposed of.
Yes. Good. My lord, item number 7, at the time of hearing, we gave some original receipt. Your lordship said after the judgment, you can take it back. Fine. In item 7, great.
That the only request is, my lord, those spiral bound volumes may be forward to the committee also, which has, my lord, so that the committee knows what is the issue.
An independent decision not being influenced by anything else.
Grateful, my lord.
They are all the experts in their own subject.
Yes.
They know all the books. They know who is the author. Let them take a decision. No,
Very well.
should not be swayed or influenced by any other extraneous factor.
No, I was only wondering,
You may
state has a representation, so at least we could also provide.
authors who have propagated their own views, including that the sun revolves around the earth, Not the earth revolves around the sun.
Very well,
What
my
to
lord.
do? Let them think.
We won't disturb them. We will just forward.
We don't have to go to them.
No, we don't want to. We just forward it.
That's why I say for each subject.
Share down.
There are multiple questions for different subjects.
Yes.
That's why I say multiple committee, but has to be.
Sad part for me is I couldn't answer even one of them.
You don't agree that the one institution is
No, I understand. But
highest pedestal and the others
no, absolutely.
have a proficiency. No.
It's a difficult question paper.
Great. Great.
Item number 9.
Yes.
Appear for the appellant in this matter. But this is an incentive related matter. This is an incentive related matter pertaining to an MSME, macro, small and medium enterprises, my lord. Your lordship had heard this matter on the last occasion, possibly your lordship is. So, my lord, if your lordship kindly comes to the impugned judgment and order which is appearing at page 364 of the stay application.
I always believe the memorandum to be a safe mode. Yes.
Now, my lord, impugned order has to be annexed to the petition. It has to be annexed in the top of the petition.
No, well, the reason is very obvious. The reason is that we have certain judges, including me, have a bad habit of putting some, underlining something.
Yes.
So the certified copy should not be touched.
It is, sir, my lord can touch. We have seen. Court is touching.
Sometimes it goes to higher up. Not good. So that's why the photocopy is annexed. We are making all these underlining in the photocopy.
Very good. Then why the top sit? At the top, there has to be a, in a civil division started.
It has to be.
One top, one annexed. Two, and another memorandum. That is memorandum of appeal. That is memorandum of appeal, certified copy.
Also, we have to see the order.
Right. Then why, my lord, at the top and on the bottom?
Why not? You want everything in the bottom. The top priority is the order.
Yes.
At the top.
Very good. Then why in the bottom? Again?
Why? That is certified copy.
No. Certified copy in the memorandum of appeal.
In civil division.
Only to bother the lawyers. Nothing.
Only thing is that bother you, that henceforth we will permit you to give file the soft copy. E-file it. Do it. No need to go into all these aspects. We will have the judgment. Whatever we want to do, we'll do it there.
The best thing, my lord, nowadays, my lord, the best.
You agree?
No, I am not. Let me go some days more. Let me leave this profession, then you will introduce this.
Your senior has adopted the technology.
No, not to that extent. Not to that extent. Not to that extent.
You will not. What are you talking?
And I have seen. Three things are common. Am I audible? Am I visible? My lord, I cannot see, my lord. These things common dialogue. They are up to matters.
Then the uniform reply is that you are visible as well as audible.
Sometimes not visible.
No, not there.
You know, this matter, well, may I say then read out the judgment? My lord, your lordship had read the judgment. Your lordship may kindly appreciate. Well, I'll just
Lot of markings are done.
well, I'll just refresh your lordship's memory. My lord, this is with regard to that this particular industry, FENA Industries, have centers in different places in India. So your lordship was first of the view, my lord's view, with regard to this matter. Since you cannot club the industries in view of a subsequent clarification by the central government that they are having industries in Delhi, in Pondicherry, in different places in India, it cannot be clubbed because central government has given clarification. So they are entitled to the incentive under the incentive scheme because this is a new unit. That was your lordship's first impression. Thereafter, I pointed out before your lordship that under the incentive scheme, my lord, there is a specific clause that if you have availed any benefit under the old scheme, then you are not entitled to this scheme. At that juncture, my lord, my learned senior friend, subject to correction, wanted to come back to your lordship to give his reply. So this had happened on the last occasion.
Where is those?
Lordship may kindly comes to the incentive scheme. The incentive scheme is at page 111.
No, you have not, in this matter, what has happened? Nutshell.
But in this matter, the petitioners approached this honorable court saying that we have been not given the eligibility.
You are starting a race from a ministry.
No, I'm starting from.
Start from the bank.
No, starting
One
from.
thing is that this petitioner is a manufacturer or what?
It's a manufacturer. It's
What
a
is the
manufacturer of a.
Where they have set up the unit.
But I'll come.
All these things just tell
Yes.
us to have.
My lord, is a manufacturer of detergent products. It says that being emboldened by a incentive scheme.
Again, you are going. First thing is manufacturer of the detergent.
Detergent.
Where they have set up the factories.
In-
Prior to this.
They have set up factories in pan India. It is in four states: Delhi, Onyx state. It's pan India, many states. And in West Bengal, it has set up its units at Howrah.
They wanted to. They have many factories, many setups in
Right.
other part of the country.
Right.
Except the West Bengal, they came and wanted to set up
A factory at Howrah.
factory unit
At Howrah.
at Howrah.
Howrah.
In the same name.
In the same name. In the same name, same directors, everything. Now, when they set up a factory at Howrah, their contention is that based on the MSME scheme of the state of West Bengal, where they have been assured under that scheme that if they set up the industry under the Howrah unit, that is the petitioner's state, then they will be entitled to several subsidies by the state government. Those subsidies includes the fixed capital investment subsidy, interest subsidy, taxation subsidy, subsidy in stamp duties, electricity subsidy, all these subsidies they will be entitled to. So when they set up the industry, they asked for eligibility cum registration certificate from the state government. The state government declined their prayer on the ground, initially on the ground.
So the initial invitation was there, you come and invest.
Yes.
And thereafter decline.
That was a universal invitation. Any MSME setting up. So initially, well, that is their case. But I'm just submitting the petitioner's case. Well, the petitioner's case is that initially when they applied for eligibility cum registration certificate, the authority concerned refused to give that eligibility cum registration certificate on the ground that already you have different units in different parts of the country. So it cannot be treated that you are a micro, small and medium enterprises and those units were clubbed together and you are a big unit, you are a large unit, you are neither a micro nor a small nor a medium enterprises. Challenging that, they had preferred a writ petition before this honorable court. They were armed with a circular or with an instruction of the MSME department of the central government, where initially the circular said that the companies in different parts of the country should be clubbed together. But immediately thereafter, the central government came up with a clarification that this particular notification is no more in existence. They cannot be clubbed together. They have to be treated as a single unit in a particular state. The petitioner's case stands on that since I am a single unit, I have set up an industry and my capacity is accordance with the MSME Act. So I am entitled to the subsidy under the MSME scheme of 2013. And since you had made a promise, you are bound to act upon such promise. That was the petitioner case. This matter came up before the Honorable Single. The Honorable Single Judge, after hearing us, my lord, we raised a point before the Honorable Single Judge that the incentive scheme has to be read in its entirety. And your lordship knows very well that in the incentive matters, there have to be strict interpretation of all the clauses and conditions of the incentive scheme. Our contention that they are not a new unit, new industrial unit under the said incentive scheme, so they are not entitled.
You defy that particular clarificatory notification issued by the
I am not.
government.
I am not touching upon that clubbing aspect. That is what my contention was before the Honorable Single Judge. My contention was reading the MSME scheme. It is crystal clear that the unit shall be treated as a new industrial unit if the unit manufactures a new item. Number one, this was one point. And second point we had raised, it is very much there in the incentive scheme, that if they have availed any benefit earlier in the state, then they will not be entitled to the same benefits under this incentive scheme.
What we mean, the clarification is a farcical approach.
Well,
The clarification says that if the unit is set up in any other state where earlier there was no such unit, then it will be treated as an independent unit for the purpose of the MESE,
MSME.
MSME, whatever, the scheme. So this clarification has come. That means that if there is a unit in other part of the state, you cannot treat it as a conglomerate of the units. You have to treat it as an independent. How you say that, yes, I can treat it as a separate unit, provided you manufacture a different item first, not the item which you have already done. Secondly, if you are not manufacturing the different item, but the same item, then if you have already availed of this benefit in any other state.
No, same state. In the state of West Bengal.
This is the first unit.
No, this is the first unit. They had already, by setting up the unit, they had already availed the benefit under the incentive scheme, under an old incentive scheme. Incentive scheme of ours.
That if you have already availed the benefit under the old scheme, you cannot set up or you cannot switch over to the new scheme.
You cannot seek benefit under the new scheme. That's
switch over.
My lord, they have founded their case on clubbing. I have not touched upon clubbing. Yes, I say that clubbing will not apply. I say that I have founded my case on the ground that you have availed a benefit. There is an admission on their part. The state of West Bengal initially had come up with an incentive scheme of 2000. There is an admission on their part that they had availed the benefit under the scheme of 2000. My lord, subsequently in 2013, when this scheme came, again they are seeking the benefit. There is a specific clause under the scheme that if you have availed the benefit in any of the earlier scheme, you will not be entitled to the benefit. Clause 6, the incentive scheme starts from page 111, 111. Page 111, the incentive scheme starts, my lord. That is the 2013 West Bengal incentive scheme for micro, small and medium enterprises. Lord, I am placing reliance upon at page 115. The last clause, clause 6, non-applicability of WBIS 2013 for MSMEs. The WBIS, that is the West Bengal Incentive Scheme 2013 for MSMEs, shall not be applicable to the industrial units, enterprises, next page, my lord, that have been registered and for which eligibility certificates have been issued, incentives have been sanctioned and or disbursed under the respective incentive scheme of the state. This will continue to be governed by the respective incentive scheme of the state. Our state, my lord, in 2000, if your lordship kindly sees paragraph 52.
What is the period of these incentives of the moratorium or what?
Well, the periods, my lord, these are, if a scheme comes for 5 years, my lord, I'm availing the benefit for 5 years.
That is, I'm talking about the duration, 5 years.
5 years. Most of the cases 5 years. But if my benefit, if my
2000 scheme also says 5 years.
Let's say 5 years. But if my benefits have not been completed within the span of 5 years, that it will continue, it will percolate for 10 years, 20 years, if those benefits are still to be disbursed to me. If your lordship kindly comes to page 50, paragraph 52 at page 80, that is the pleading at writ petition. This is paragraph 52 of the writ petition, page 80 of the stay application, my lord. My lord, it is very much pertinent to mention here that the said unit of the petitioner company at Howrah had also applied for another scheme of the government of West Bengal under the finance department, namely the West Bengal Industrial Promotion Assistance to Industrial Unit Scheme 2010, being amended each and every financial year up to 2019 as a small scale enterprise, and the government of West Bengal has considered the said unit of the petitioner company as a small scale enterprise and refunded central sales tax and value added tax against industrial promotion scheme for the financial year 2015-16, 16-17, 17-18 as per the said scheme of 2010, which was amended in every financial year up to 2019. So they had been availing the benefit up to 2019. So my lord, our contention before the honorable single judge that they, my lord, by placing reliance upon this 6-1, by placing reliance upon 6-1, that they have been registered and for which, my lord, that was completely, my lord, ignored with deepest of respect by the honorable single judge, my lord. Because the honorable single judge all along proceeded that you cannot club together. And we, my lord, we had considered to that point, yes, clubbing cannot be done because there is a clarificatory circular that clubbing cannot be done.
Yes.
My lord, one আর বাংলা মামলা 3 নম্বর আইটেম আছে অভিষেক পল চৌধুরী 9 নম্বর ওটা বন্ধ
Say about this clause at 170. 105.
An eligible enterprise which has availed of incentive subsidy in respect of any of the items specified under any other incentive subsidy scheme of government of state shall also be eligible to get the benefits of other items. For instance, my lord, if
You are manufacturing, say, the cubes, and later on you say that I want to manufacture the ingots.
my lord.
Is there another item?
No.
Item of incentive.
What is this item?
Item of
Incentive. Well, may I clarify?
Item of
Incentive.
My lord, there are
I just reacted to it.
My lord.
What is the response?
My lord, items, my lord. I don't know if a senior friend is complete that. Items under the incentives are several items. Under a particular incentive scheme, my lord, we have a fixed capital investment subsidy. We have a loan subsidy. We have an electricity subsidy. We have a tax rebate subsidy. So if any particular unit is availing these 2 items under a particular scheme, then he will be entitled to avail, except those 2 items, other items under this incentive scheme.
For the same product.
For the same product, my lord, your lordship kindly sees the product.
Does not talk about the item.
Well, this particular scheme is applicable to new industrial unit. And if your lordship kindly comes to the definition of new industrial unit,
So I understand, because it talks about any of the items specified in the scheme. Suppose the scheme is specified. The scheme earlier specified A and B.
B. And
Then another scheme comes which talks about C and D.
A, B, C, and D.
One can avail. This is what?
But
Say in a
I'm good.
simple way.
Simple way. A, B should be left or C, D, I'll get. Now, my lord, if your lordship kindly sees the new industrial unit definition.
There is a marking by me earlier.
We were, my lord, because we were doing that. Now, if you kindly sees, there is a marking possibly of at page 113 also. 113.
Oh, 113, I do not have.
But at the top, new industrial unit. New industrial unit means a micro, small, or medium enterprise in the manufacturing sector which has started production on or after 1st April 2013 and filed EM is Entrepreneurs Memorandum. Part 2. If an existing industrial unit sets up a branch as second, third unit, etc., in different location in the state and manufactures new items, its second, third unit will only be treated as a new industrial unit provided EM Part 2 is filed for the same.
So you have really extended it.
My lord, here, my lord, I'm subject to my lord's my lord, correction, my lord, sanction. My lord, here, my lord, our interpretation, my lord, if an existing industrial unit, my lord, when an existing industrial unit throughout the country,
No, state not say.
my lord, if an existing, my lord,
Talks about within the state.
I'll just, my lord, if an existing industrial unit,
The meaning of the word in the different locations in the state.
if in different location in the state, in the state,
One manufacturing unit was set up in Uluru.
and he sets up a second,
In the Siliguri, the state, then in that event, he is also entitled to get, provided he filed EM Part 2.
But,
So that's a very simple way of understanding the language.
my lord,
The authorities may weirdly interpret anything, but the language is so explicit.
your lordship, just,
Require
I'll just try to read it, my lord, if your lordship kindly allows me.
any more.
If an existing industrial unit, for a second, your lordship, just consider that it's existing industrial unit in different, just for my satisfaction.
New
Well,
industrial
I'll just
defined.
Ah.
New industrial unit is defined.
Ah.
Which says, let me read in my own way what I read.
Means the micro,
Will you clarify? Means a micro,
small,
small or medium enterprise in the manufacturing sector which has started production on and after 1st April 2013 and filed EM Part 2, then you should stop. So there is a full stop. So it says that the new industrial unit should be micro, small and medium enterprises who has started manufacturing on and after the date, that is the 1st April 2013, and also filed the EM Part 2. Then it says, next sentence, if an existing industrial unit, so two, one is set up, started production after 1st April
and filed EM Part 2, my lord. If an
says if existing industrial unit is there is already an existing
industrial unit sets up a
branch, means what? It's a extended arm.
branch. Yes. It sets up a branch.
Extended arm.
Sets up a branch.
And second or third unit means they are also treating it as a unit.
Yes. In
different location in the state means within the state at different locations. If they set up and manufacture new item, now here is something new, another product item. Its second or third unit, etc., will only be treated as a new industrial unit, provided EM Part 2 is filed for the same. For the same means for that newly set up branch or a unit within the state for manufacturing of new items.
But it may be read as like this also, if your lordship kindly, my lord. I may not be able to convince. I may not be able to convince your lordship.
No. Then what you want to read? Tell me. Read.
Well, if an
I have read it in my way.
Well, if an existing industrial unit, not in the state, it says existing industrial unit. It is not saying if an existing industrial unit in the state. It does not say. It says if an existing industrial unit sets up a branch as second. Your lordship may kindly ignore third because second or third as second unit in different location in the state.
The word different location.
Second unit in
these location in state. Why I have read in a school does not impart a good education in English.
Because, my lord, there is.
But any sensible man, if he reads this sentence, that if an existing means the unit which is in existence.
My lord, that is,
already
my
set
lord,
up. If the existing industrial unit sets up a branch as a second or third unit, etc., in different location in the state. When it talks about a different locations in the state,
my lord, my lord, that is,
conveys a very clear
my lord, my lord,
that there is already an
my lord, I have,
industrial unit in the state.
my lord, I failed to convince your lordship with regard to that. But,
That's a simple English one can
my lord,
understand.
my lord, but with regard to, my lord, this,
Now, what should be the another mode of expressing
my lord,
it, Mr. Siddiqui?
my lord,
Let us test.
no, my lord,
Could be the best way.
not,
What we are thinking
my lord, I,
could have been the best language. Tell me.
but the language has not been properly couched. My lord, according to me, according to me, the language should have been couched if an existing industrial unit in different parts of India sets up a unit in the state, then it will be treated as a unit.
Was that an
Well, it has not been properly
was
couched.
that an intention?
It was not properly couched. But my lord,
Then I tell you,
but since my lord,
that the existing word should not be used. What you say, then the language would be, if the industrial unit sets up a branch, then the different word has to be deleted in the state. Then, and manufactures new item, then it will be treated as a new industry.
but at the present moment, my lordship may kindly get.
But different, well, anyhow,
Lord,
statutory provision.
my lord, we will not go into that new unit, my lord. At the present moment, my lord, I am, my lord, laying stress upon that they are already availing the benefit as admitted. But I am, my lord,
When you took us here, then that's
my lord,
I
well,
told
that day also I took you, but to my lordship, that I was not able to convince. Well, that day I asked
to know your
the other,
conscience well.
well, the other day,
For the sake of
well, the,
you are arguing
well,
with
the other day, my lord, I started my argument from that point, my lordship was not convinced. Subsequently, when I came to this particular point, that they are already availing the benefit, then my lord, then my learned senior friend, my lord, sought for time to come to your lordship, my lord. That is the case. Now, my lord, may I place the judgment, my lord? Your lordship has already read the judgment. But I have got an authority with regard to how the incentives, my lord, I've got authority, how the incentive schemes has to be read. Right. It cannot be loosely read. All the clauses of the incentive scheme, my lord, has to be read.
you have that in mind while arguing this point.
Okay.
হতে পারে
জাজমেন্ট দেখাচ্ছিস কিছু?
এই জাজমেন্ট আছে দেখিয়ে দিই তাহলে লাগবে না my learned senior friend insists that I should place that judgment.
No, I don't insist. You say that I have.
My learned friend, senior friend, the 2018 volume 9 Supreme Court cases, page 1, paragraph 52, 53 and 66. বলবো না পড়া দরকার নেই
3 and 66.
52, 53, 66. স্কিমেতে যে বেনিফিটটা নিচ্ছি এই স্কিমে আমরা ওই বেনিফিটটা নেব এই স্কিমে এক্সপেক্ট মানে
Out of the context, I am hoping that this kind of an argument is advanced at a later point of time.
Which man? I
So, advance.
then
I would love to see
No, no.
the reaction.
my lord will not be able to see that. We will see that, and the common dialogue is there. Forget those days when I was in the bar. My lord, forget that statement. So
এটা রেখে নিন এটা দাদা অ্যাফিলিয়েটেড সেমিস্টার হয়ে গেছে রেখে রাখুন।
What all you are citing this judgment, paragraph 52 and 52.
Paragraph 52 में लॉर्ड
This is in relation to an income tax or a customs.
मतलब with regard to any
These are all the revenue statutes. The very fundamental principles relating to interpretation of the provisions in the taxing statutes or the revenue statutes are that in case of any two possible interpretation. First thing is they go to the benefit of the SSE. Secondly, what it says is if there is any exemption which is provided in the act,
मतलब it should be
then it should go in favor of the taxing authority.
it should be interpreted
Now,
strictly.
exemption is what?
Exemption under the
Customs
custom.
Act and under the Income Tax Act, there are two kinds. These are the different exemptions.
Exemptions.
One is under the Income Tax Act, allowable expenditure. There are certain components which are exempted from the
Tax.
brought within the purview of the taxable income. If this exemption is one place, then the interpretation should be stricter because something is claimed as a benefit, which cannot be. In a customs also, there are certain exemption which is provided.
Certain goods are exempted from customs duty.
These are the items. Then there should be a stricter view in this. Yeah, the scheme, the benefit of the scheme is
Beneficial scheme.
extended. Now, whether interpretation at the time of awarding the benefit, because it is a beneficial piece of legislation,
My lord.
and for whose benefit these acts have been introduced?
For setting up industries.
State benefit.
For the
State's benefit.
individual entrepreneur,
My lord.
just to lure them, may I use the word? Not invite them, lure them to come and make an investment within the state, so as they will be a part of the economic development of the state.
And
Employment.
also employment generation.
Therefore, not only the act, but the promissory estoppel should also stand in the way.
That is, my lord, there. We have argued that and court has accepted that.
Right.
Otherwise,
Oh, my lord,
it will
what-
be detrimental to this, to
My lord, the scheme,
unit.
my lord, the schemes, my lord, subject to correction by my lord, but the scheme gives, my lord, the benefits which are coming under the schemes are mostly in the nature of exemptions.
Yes.
The tax exemptions are there under the scheme.
No, these
Now,
are-
if
these
I am
are-
entitled
these
to
are
pay,
all-
Ah.
these are all- there would be a refund. It's not an exemption. That's why I'm saying exemption means it cannot be brought within the purview.
my lord,
Here you are not doing it. They must pay. You will refund it.
I will refund the tax amount.
This is what? It's an incentive scheme. It is not an exemption. Exemption when? Suppose the depreciation claimed on purchase of the books and periodicals by the lawyer is exempted.
ওটা দেখো। 100 কত বললেন?
Then it will not be brought within that bracket. Income tax authority is not supposed to refund it. It is absolutely kept outside the purview of taxable income. Exemption means that it will not be brought at all. But once you say that, no, you must pay, I will giving you an incentive, I will return you this money. If you make a claim, it's not an exemption.
That is
But
section
if, my lord,
115
at the end, my lord, it comes exemption because I have paid, but I get back everything. So I'm paying nothing. I'm paying nothing.
I inculcated this after taking a revenue bench for a long time.
No, he is
But
now
I have-
revenue expert.
What?
He is every day appearing in revenue court.
Anyhow,
No, well, may I answer? I will not make elaborate argument because he has considered that clubbing is illegal. He has considered that new enterprise my lord are interpreted. I will not go into that. This is my submission. My lord has. Now, only question is whether by availing one scheme, I will be debarred from getting this benefit.
Correct.
My lord, kindly come to 200. No, first 117. 117 kindly come.
That is the clause.
That's the court. clause.
Yes, clause 5.
May I read with your lordship? Clause 5.
I have a marking.
Yes, yes, on other date. An eligible enterprise which has availed of incentive, subsidy in respect of any of the items, but these items is item of subsidy.
Specified under
Subsidy.
any other scheme.
No, I am saying this is item is not the product. Item is item of subsidy.
Is provided in this scheme.
Is there any clarification?
Not necessary. My lord, if your lordship,
So can you show me the item is specified in the scheme?
Yes, yes, yes. Sage,
and may I read that? The item specified under any other incentive subsidy scheme of the government of India, state government. This subsidy item, not the product. This is our submission. This is item subsidy.
page
This can be, my lord, ascertained, my lord, when they ask me that these are the shortfalls of yours for your non-entitlement, that your lordship will get at page 192.
So that what are the subsidies?
দেখাচ্ছি. The government of West Bengal is saying clarification about incomplete and defective application under Form A. Kindly come to with relevance to your application to state incentives such and such 13, dated such and such. After scrutiny, it has been lead that a number of statutory documents are not enclosed which are mandatory during submission of filing application. Kindly come to 3. Deducts 92. Declaration about existing manufacturing activities in West Bengal, stating items, annual approval capacity, annual production during the last 3 years. 6. Receipted copy of the application submitted to the Commissioner Commercial Tax West Bengal in respect of TE receipt of claim upon entry of excise tax, VAT and GST. Because in the earlier scheme we have availed of this.
Only that.
That's why they asked me to produce those documents. Ask. Am I clear to my?
What about 7?
7. Safe declaration as para 7 of the scheme. Mine will get the answer next page. They ask for the declaration that when you are availing under the 13th scheme, this A, B subsidy, sale tax subsidy, you will not ask for it. We made the declaration.
What?
That the 7 is speaks for 6 speaks for that what I am receiving under the scheme, the subsidy items. Previous scheme that you have produced the receipt. That receipt was produced with the declaration. That you will also get at page next page. Kindly come to 6. Declaration regarding application submitted to Commercial Tax West Bengal. And the declaration I have because they have the declaration copy with us because they have not raised this point in the affidavit. There we categorically said we are receiving the subsidy on that item, so we will not ask for under this scheme. And that's the requirement they asked for. দুটো গেছে
ডিভিশন
তিনটে দিয়েছি
কপি আছে শান
yes sir yes sir But this is not the part of the record because they have not taken this point. Correct. না নিতাম
গেমটা ম্যানেজ করা আছে
So you take that, but
it's 294
Yes.
well, that this is not part of the record because they have not taken this point. I am just satisfying my lord's query. In the affidavit, in the pleadings, accepting the point of clubbing, no point has been taken. All are now from the bar. The order impugned speaks only that you cannot be granted because you are not an unit under this scheme.
This point has been
Your question of law, they want to make
On the basis of facts.
of your admitted fact.
On the basis of what is the admitted fact?
That I
They-
am awaiting an earlier, the benefits under the earlier scheme. So I am not entitled, he is not entitled to.
That is not the case made out by them. Even if I am satisfying my lord's query.
Your own admission he is relying on, he is not
Yes.
saying anything. He says that.
That
you
I am
have
satisfying my lord.
that you are there. These are the provisions of the scheme which says that you cannot get it. That's all.
I have shown to your lordship. Now kindly come to the 2013 scheme. What are the subsidies there?
2010.
I am availing 2010 scheme. Sorry, my lord, my learned friend corrected me.
99 page.
Kindly come to 299. 299, that scheme. পড়াই যাচ্ছে না।
Entitlement industrial process are registered. Actually, do only value added tax.
My lord, this is, my lord, can you read that? Don't scold me, my lord. It is only value added tax is the subsidy there.
Where do I get?
That 3A.
Oh, yeah.
Sorry, my.
Only got also.
This value added tax is the subsidy there. We applied for that. We're entitled. I am has been given to me. I am availing this subsidy. That's why they asked me by writing that you give a certificate.
This is all the public document. Why don't you take it out from the website?
Not probably
What
not
are you doing?
available. Oh, yeah,
Thing was not available.
What are you talking? It is already published in the official gazette. Must be there on the website.
This is the copy which was filed by them.
Sir,
Yeah, understand.
sir. Now you younger generation are too tech savvy.
আমাকে বলছে না এটা।
Can't you go
আমাকে বলছে না।
My mistake, my lord.
on the official website and then find out
This
you
is,
have
my
the-
lord.
or the number and the date.
No, if you lordship look, you can read it at that and corresponding documents which they have asked for and we have submitted the declaration will reveal that this is only for value added tax. And there is no prohibition under any of the scheme that if you are getting any item of subsidy in any scheme, you are debarred. That item you are debarred. In that item of subsidy, you are debarred. That's why this declaration was sought for and we have given that declaration.
Yes.
So, my lord, the 3 points they sought to raise, my lord. One, my lord has clarified. One, I am clarifying, and he has one considered.
And what this scheme is providing it.
Hmm?
এই স্কিমে কি কি দিচ্ছে সেটা একবার দেখি।
Yes,
100
my lord, if you lordship compare the 2010 scheme only VAT, but this scheme more than that. Page টা বলে একবার।
109.
119 kindly come. Many things.
First is state capital investment subsidy 9-10 পরপর পাচ্ছে।
My lord,
Not
kindly many items they are giving subsidy here. It starts from 119. State capital investment subsidy, then interest subsidy, then, my lord, waiver of electricity duty, then power subsidy, subsidy of energy efficiency, subsidy on stamp duty and registration fees, round of refund of entry tax, refund of value added tax that I have considered. I will not. Refund of so many items are there. Certainly, if I am availing one item of subsidy, I cannot get another item, same item.
So this is the item of the subsidy scheme, or the item of the product which are manufactured.
Yes.
So that word item to be read along with the item of subsidies. These are the item of subsidy.
Yes.
117.
17 clause.
Pilot has already read this clause 5 at page 117. An eligible enterprise which has availed of incentive subsidy of respect of any of the items specified under any other incentive scheme.
Government of state of shall also be eligible to get the benefits of other items.
Language is very clear. I am entitled to get the benefit of other items. Other items, we are entitled. So it is clear. Not only department is not there, it is otherwise clear that if I am availing of other items, I can get. And now my lord, before I conclude, my lord, I will submit before my lord. The rejection is, my subsidy rejection is only on the ground of clubbing. That my lord has
Set aside by the single bench.
yes.
For the single bench, they have
And
argued this point.
before the honorable single judge, my lord, orally this point was argued, and that court has taken care of that without any pleading.
Yeah, the court has taken.
Yes. My lord, kindly come to point gulo boleছিস.
Para 25.
Kindly come to paragraph.
Para 26.
দাঁড়া. Court has firstly said, may I read paragraph 23 plus first. The only ground on which the application for incentive of the petitioner company under the incentive scheme for its unit at Howrah was rejected was that after clubbing of investment in plant and machinery of various units of the petitioner situated in different parts of the country, the threshold limit has exceeded. No other reason was cited in the orders of rejection dated such and such. This court has already observed that for the purpose of classification of a unit as micro, small, and medium enterprise, investment of different enterprise set up by the same person cannot be clubbed. Therefore, there is no foundational basis of the aforesaid order of rejection. Now, kindly come to 26. This oral submission. The learned advocate for the state would vehemently contended that the petitioner received the benefits of the West Bengal Industrial Promotion Scheme 2010 and therefore is not entitled to the benefit of the scheme incentive scheme of 2013. It appears from the record that the petitioner applied for the incentive scheme 2013 for power subsidy, subsidy on stamp duty and registration fees, refund of entry tax, refund of VAT and CST, and workforce welfare assistance. Explanation 5 of clause 7 of the incentive scheme 2013 specifically states that an eligible enterprise which has availed of incentive subsidy in respect of any of the items specified under any other incentive scheme of Government of India also be eligible to get the benefit of other items only under the incentive scheme of 2013 for MSME subject to fulfillment of terms and conditions of the scheme. The learned advocate for the respondent failed to demonstrate before this court that the Howrah unit of the petitioner company availed of the benefits in respect of the aforesaid item under the 2010 scheme. This court therefore holds that merely because the petitioner company availed of certain benefits under 2010 scheme, that by itself cannot be disentitled the petitioner company of the benefit of the incentive scheme of 2013. And that part my lord has clarified. So I did not make any.
What clarified?
That unit, my lord has also asked him what other interpretation.
In order to ascertain the
Yes, the real intention is really.
observation is not sacrosanct.
No. What I'm saying,
Comma class sometimes.
there cannot be any other interpretation of that language, the statements made in that paragraph, that scheme. If an existing unit has to be read in the state, make his branch. Here, this fact is not that. I have only existing one unit here. I have an unit in other state. I think I should not make any more submission in this aspect. So far as
Yes, abandoned that claim.
yes, those claims.
That I have not
And section 115 is squarely applies, my lord. 115 of evidence squarely applies. They promise us. Promissory estoppel is there. We have, on the basis of the promise, we have acted detrimental to our interest. Yes, we have spent money. We have established the unit on the. Yes,
beneficial to your.
No, not a beneficial will be after I get the subsidy. After I get the subsidy, it will be beneficial. Before that, my lord, if I don't get it, then it is a wrong investment.
Yes.
My lord, that the promissory estoppel will not come in this case, my lord. If your lordship kindly sees paragraph 7 at page 9 of the writ petition, page 49 of the stay application. No, no. Reply, আমার তো last, আমি তো শেষ।
So he is saying promissory estoppel.
Promissory estoppel will not come into. Paragraph 7 at page 49, my lord. It is an admitted case. Your lordship kindly sees page 49. It is paragraph 7 of the writ petition. The petitioner states that after coming to know about the said incentive scheme of 2013, the petitioner company, as per the said incentive scheme, on 5th April 2013.
So you wanted to say the promissory estoppel will apply when they first time came under the 2010 scheme and invested.
Not only this, my lord, they have said all along, all along they have said they have started the unit on 5th April 2013. Lordship, may kindly mark that date. Now, my lord, this incentive scheme, which is appearing at page 111, this came into being on 3rd of February 2014.
I think what I am
So,
saying that sometimes,
Said that.
sometimes
Uh,
the language, for the foreign
and in
language is
2000
concerned,
Yes.
many of the members, they do not agree because they wanted the judge should speak the same word
Ah,
and
man.
the sentence
It will not fit in here.
it will not fit here.
which they think should be uttered.
It will not be.
So happened.
No,
Uh,
but, no,
my lord,
I am
my lord.
withdrawing it.
No, my lord,
It
he,
is not fitted
my
here.
lord, my learned friends possibly missed that date.
So what I said,
uh.
when he talks about the promissory estoppel concern, and then say that you promised us to do something, and thereafter you retracted from your promise. This is what a promissory estoppel
আগেরটাই
is.
আমি অ্যাপ্লাই করেছি না।
This is definitely a scheme came subsequent to their existence in the
Yes, yes.
scheme.
The model is correct.
So that is what I say.
Yes, yes.
That the promissory
Absolutely.
estoppel may have
It's true.
this application when they came for the first time or availing
And that scheme.
incentive benefits under 2010 scheme.
It is in the existence.
Once they availed, and if the subsequent scheme has come,
তোর মামলা জজ করে
there
দিয়েছে যা।
cannot be a promissory estoppel.
Even in paragraph 3, if your lordship kindly sees. Well, even in paragraph 3, there is no promissory estoppel.
হয়ে গেছে তো। তোমার মামলা তো জজই নিয়ে নিয়েছে।
One has to prove that how to write a judgment in a very
My lord, that's that dark na re kaunte. But I am grateful to Lord.
শিখে নিবি এখান থেকে, এটা থেকে, এই জাজমেন্টটা থেকে।
Madam.
এই হয়।
let us come back and dictate.
Can you pardon my absence?
My lord, I will.
In other.
This is also not required.
My lord, I will be also taking your lordship's leave.
While you are standing,
Next one.
you have to dictate the order. Approve the response. Assuming the citizens have order of the general manager, district industrial center, Howrah. Communicating these letters of our diverse deeds. To writ of mandamus. Extend the eligibility come registration certificate as a small enterprise under West Bengal Incentive Scheme 2013 and the benefits arising therefrom. Undeniably, the respondents are the manufacturer of the detergent soaps. Having several units pan India. And subsequently set up a manufacturing unit within the state of West Bengal to avail the benefits as the state intended to extend to the various manufacturers upon promulgating Bengal Incentive Scheme 2010.
This one is 2013 scheme, man.
What one is 2010?
2010 scheme, man.
Huh?
This is 2010 scheme. 10.
10. The unit was set up and the benefit under the said scheme was availed of. And to that regard, there does not appear to be any dispute. However, subsequently, another incentive scheme of 2013 or 16,
2013.
13 was promulgated Yes.
I'm appearing on behalf of the District Primary School Council, Nodia.
Last petition, my lord, has been pleased to adjourn the matter on the ground that they will obtain an instructions. My lord, paper book ta din. The paper book has come up. What they said, my lord, kindly see. Number, page 44, 45, 47. My lord, just one. My lord, kindly turn to page 53. What they said regarding that. In our earlier writ petition, my lord, regarding creation of that vacancy.
So it means that he was not under the OBC. Santanu Park was not under the OBC category.
My lord, they said that.
Yes.
So, my lord, they have refused my prayer. I have preferred a writ petition. Now, the instant writ petition. Why, my lord?
Under the combined panel.
Not the combined.
Kindly mark it, my lord, combined panel. Because he was sponsored under the OBC. My lord, he was
Meritorious.
yes, meritorious. Combined panel. Yes, my lord.
Now, my lord, kindly come to page 82 once. This is the judgment passed in another matter pertaining to the same panel. Page 83 is the relevant part where the council admits they said in my affidavit last cut-off marks was 41.21. Now what they say, my lord, kindly see. Pursuing the same, it appears that it has been categorically stated that as per the court's direction, the office of the chairman, District Primary School Council, Nadia, prepared a panel consisting 1:10 basis. It further appears therefrom that
39.61.
yes,
I got you.
my lord, page 86, my lord, kindly see. Regarding that, I filed annexing this order. My lord, I have filed a CAN application. There was an order passed for filing of affidavits. Affidavits has been filed.
Yes.
Now, my lord, kindly come to the order impugned.
Oh, that I've seen. Order impugned.
Order impugned, they say 41.23.
What we have to continue. We have another page.
My lord.
Continue after 2. If we can sit, then it's all right. Come on, Tuesday.
My lord, then, my lord, keep it on Tuesday, my lord.
Tuesday.
Tuesday.
Because my lord, similar matter fixed on Tuesday. My lord, my learned friend referring my lord, another my lord, writ petition which appeal is fixed on the similar issue Tuesday.
They come on Tuesday then.
My lord, it will retain its position. Grateful to your lordship.
শুভব্রত ভট্টাচার্যের 10টা অ্যাপিল আছে
My lord,
Urgent mentioning of another
I'm
report number
seeking
1.
leave.
Lordship, may I be permitted to mention a matter?
Mention the matter before.
Yes,
Not chair.
my lord, I'm seeking leave to file a public interest litigation on behalf of the victim father, my lord. The FIR was, after registering the FIR, the police authority did not following the prescribed manner in the act. Well, may it appear on the Tuesday, my lord.
May I be permitted to mention one matter? This is a review application, Lordship. Your Lordship was hearing this application, this bench.
no other mentioning? Then what matter is listed?
Yes, Lord, it's as item number 1, the list of Honorable Chief Justice.
এখন নেওয়ার জন্য একটা সময় না দুটো সময় লেখা আছে লেখা নেই তো তখন
Lord, all the parties are present, I think.
Well, I am appearing for the state led by the learned advocate general. He is supposed to appear online, Madam.
I have served, Lord,
Lord, I am appearing online, my lord. Kindly permit me to address the court
I
online.
have also served, Lord, the persons, Lord, who would organize such meeting. I have made them parties. The, I don't know whether anybody,
why come at 2
Oh.
I will come at 2 p.m.
I see.
Because it has to be done at supplementary. And supplementary list is to be
Very well, Lord, we'll come back at 2 p.m.
come at 2 p.m.
Come back.
দেখা যাচ্ছে না স্ক্রিনটা স্ক্রিনটা একটু
Supplementary list, item number 1.
Lord, I beg to appear, Lord, on behalf of the state.
Yes. Lord, the subject matter is, Lord, a march to Novanno. That's the subject matter of this writ petition. Lord, your Lord kindly sees, Lord, it says at the instance of Paschim Bongo Chhatro Samaj. Kindly have a look at page 27. Lord, my client, Lord, he is a practicing advocate of this honorable court. Lord, despite best endeavor, Lord, we have not been able to find out whether it's not a political body registered. And Lord, there is no registered body or society under this name, Paschim Bongo Chhatro Samaj. But we have made this gentleman a party, Obi Mukherjee, your lordships will find at page 27 on the right hand side. We have made him a party, we have served him. Now, Lord, the invitation is that from each family, one person should join the rally. And then, Lord, there are number of other.
But it is also indicated in at page 27.
Yes.
That there will not be any violence.
Yes, yes.
And they wanted the police to be present
Absolutely.
there. That is also indicated therein.
Lord, my writ petition is not, Lord, for stopping the march. My writ petition is that, Lord, it has to be regulated because, Lord, peaceful demonstration is a part of the constitutional right.
Is a fundamental right.
Fundamental right under Article 19, 1A and 9B.
Yes.
Now, Lord, but this is governed by Article 19.2.
2. Reasonable restrictions.
Reasonable
restrictions.
Now, that has been spelled out in several judgments of the Supreme Court. I'll rely on 2. Because, Lord, this Shaheen Bagh judgment and, Lord, the Jantar Mantar judgment, these are the 2 judgments where, Lord, these reasonable restrictions have been spelled out. Lord, my apprehension is that, Lord, I am a resident of Howrah. And last time, when there was, on 3 occasions, when Lord, the people went to Novanno, there were mass scale violence. Lord, the stone pelting, damage to public property, private properties, the cars were broken. And Lord, this is the main arterial road which connects, Lord, the highways. So, Lord, there are a lot of, Lord, vehicles which ply through this road. So therefore, Lord, hospitals. There are hospitals, Lord, there are colleges, there are, Lord, public utilities, Lord, bus terminals, Lord, therefore, this is a petition, Lord, where I want that the petitioner should not obtain the permission because I find.
Where is the law relating to permission?
Law relating to permission? Yes. Lord, kindly, Lord, first consider 2018, volume 17, SCC 324. This comes under police regulation. 2018, volume 17. আমার বইটা দিতে বল আমার বইটা দিতে আমার বইটা page 324. 324. 324.
Yes, which
Lord,
portion you want
first,
to
Lord,
rely
come to paragraph 48. We may state at the outset that none of the parties have joined issue insofar as law on the subject is concerned, undoubtedly holding peaceful demonstrations by the citizenry in order to air its grievance and to ensure that these grievances are heard in the relevant quarters is its fundamental right. This right is specially enshrined under Article 19A, 19(1)(b) Constitution of India. 19(1)(a) confers a very valuable right on the citizen, namely right of free speech. Likewise, Article 19(1)(b) gives the right to assemble peacefully and without arms. Together with these rights, ensure
These are the right emanating from part 3.
Yes. Now kindly come to
19(1)(a) and B.
Yes. Now, my lord, kindly come to paragraph 56. Rather, my lord, 55 first. Well, Article 19(2)(6) is, my lord, considered. And my lord, reasonable restrictions under 19(2) is set out under paragraph 55, which your lordships kindly take note.
Yes, yes. Yes.
Then, my lord, 59 onwards, my lord, certain judgments are considered. Please come to paragraph 61, page 371. Undoubtedly, right of people to hold peaceful protests and demonstrations, etc., is a fundamental right guaranteed under Article 19(1)(a)(b). The question is as to whether disturbances, etc., caused by it to the residents, as mentioned in detail by NGT, is a larger public interest which outweighs the rights to protest to hold demonstration at Jantar Mantar Road and therefore amounts to reasonable restrictions in curbing such demonstration. Here we agree with the detailed reasoning given by the NGT that holding of demonstration in a way it has been happening, it's causing serious discomfort and harassment to the residents. At the same time, it is also to be kept in mind for quite some time, Jantar Mantar has been chosen as a place for holding demonstration and was earmarked by the authorities as well. Going by the dicta in Asha Ranjan, the principles of primacy cannot be given to one right, whereby the right of the other gets totally extinguished. Total extinction is not balancing. Balancing would mean curtailing one right of one class to some extent so that right of the other class is also protected. Then, Lord, please come to 62. Lord, kindly come to placitum D.
There's no placitum in SCC online.
I'm so sorry.
That's the whole problem.
Then, Lord, kindly take last 6 lines, sentence starting with the word the authorities could also examine.
Ensure.
While allowing such demonstration,
Not examine.
the authorities could also examine.
Examine. We have got
I see. Page number
ensured.
60, second line. Page number 60, second line.
Oh, paragraph 62, the last 6 lines. The authorities could also examine, it is.
Yes.
While allowing such demonstration as to number of protesters who are likely to participate and could refuse permission to hold any such demonstration, etc., when the number is going to be abnormally large, which, if allowed, would per se create hardship of various kinds to the residents. These are some of the examples given by us. The underlying message is that certain categories of peaceful protests of demonstration in a guarded and regulated manner could be allowed so as to enable the protesters to exercise their right and at the same time ensuring that no inconvenience of any kind is caused to the residents. Then, Lord, please come to paragraph 64. At this juncture, while discussing the aspect of balancing of the two rights, we have to keep in mind certain other relevant factors as well. In the first instance, what needs to be noted is that the portion of Ramlila Maidan, what has been earmarked for such demonstration, Lord, that's not important. Your Lordships may kindly come down about 8 lines from there. The sentence starting with the word at the same time. Has your Lordship got that? Lord, it says this may be correct. Has your Lordship got that? Lord, about 3 lines, 4 lines from there, where I was reading.
Page number 60, the 4 lines from the bottom.
This may be correct. However, it is also to be borne in mind what we are living in an era of technology where a concerned voice of a group of persons can reach the right quarters by numerous means. Electronic and print media play a pivotal role. Then when we have social media and various applications like WhatsApp, Twitter, Instagram, etc., which take no time in spreading such events. Secondly, though the holding protest and demonstration is an accepted right, at the same time, nobody can claim that I have a right to hold demonstration at one particular area only. While regulating such demonstration in public interest, particular area can be earmarked. On the other hand, it is also to be acknowledged that Ramlila Maidan may not be sufficient to cater to this requirement. Again, in this place, an old Delhi in a part of very congested area, etc. Then, Lord, please come to the last 4 lines. Sentence starting with the word balancing can be done. Has your Lordship got that? Balancing can be done by permitting a limited part of this area for holding peaceful public meeting, processions, etc., at least 2 small groups, and in such a manner that there is no disturbance or inconvenience of any nature whatsoever insofar as residents are concerned. Then, Lord, paragraph 65. Having regard to the aforesaid discussion, we direct the Commissioner Police New Delhi in consultation with the other agencies concerned to devise a proper mechanism for limited use of the area for such purposes, but to ensure that demonstration, etc., are regulated in such a manner that these do not cause any disturbance to the residents of Jantar Mantar Road or the officers situated there. Detailed guidelines in this respect can be formulated. We may also clarify that the provisions can be made for taking requisite prior permission from the police commissioner or his delegated authority for holding such demonstration by a particular group, and while examining such proposal, the parameters can be laid down and shall be looked into in order to decide whether the permission is to be granted or not. 2 months' time, etc. Here, Lord, there is a provision in Lord exercise of power, Lord, under Article 19(2), where, Lord, there is a provision that there's a permission from the commissioner has to be taken. And Lord, in giving that permission, Lord, responsibility is fixed of the person who's taking permission. Because if something, Lord, God forbid, some untoward incident happens, then, Lord, somebody has to come forward and take the responsibility. Now, Lord, it will appear from the petition that, Lord, my inquiry to the commissioner showed that nobody has applied for permission. In the previous years, your Lordships will see page 51. In the previous occasions, what happened, your Lordships will see, Lord, large scale, Lord, violence and bloodshed had taken place. Page 51. Lord, we, as the residents of the area, Lord, the petitioner, Lord, wants that peace should retain. Absolutely. Lord, there is no question. Lord, they can do it peacefully. There is no problem. But this is what it is. And Lord, paragraph 68, your Lordships have taken note of. Paragraph 70 also, Lord, can be looked into by your Lordship. Paragraph 70 can be also looked into by your Lordship, where, Lord, the direction was that a proper guideline should be framed insofar as, Lord, peaceful demonstration is concerned.
Everything you have taken very strictly. You have followed that particular guidelines in a very, rigid manner. I think so. When you take that plea, I think everywhere you have followed these guidelines.
Lord, insofar as
these demonstrations, when you talk about that, unless the permission is sought, nothing can be done. Now, tell us whether all such demonstrations which were peaceful, the permission was sought.
Lord, that
including the demonstrations or the rally which was taken by the members of your bar. Was there any permission taken from the Commissioner of Police, as you say?
That so far as members of the bar is concerned, it was in the High Court area. I
No,
don't
sir.
think we
No,
enforced
sir.
upon.
It was. Was there any permission sought? Whether you have taken anything?
Lord, kindly, Lord, consider
There are
the
many, if the peaceful protests are being given, now the Supreme Court has also said that they have not injuncted
no,
from
there is
a
no question of injunction.
peaceful protest to be given.
No, even
Uh,
in the last order of the Supreme Court says
There is
that
a clarification.
There
There is a clarification which says that we have not injuncted from holding the peaceful protest.
Kindly, my lord, see
If I
the,
correctly remember,
no, kindly, my lord, see the order of 22nd
paragraph
August.
9 of the
Paragraph
order,
9.
kindly
Yes.
look at it.
Yes. Paragraph 9. Kindly have a
Look
look.
at it. Whether it says, Supreme Court says, no, I have not injuncted.
It says that, however, we categorically
No,
reaffirm
you
that
read that word which says that I have not injuncted. Sentence prior to that.
this court has not injuncted the
Correct.
state from exercising such lawful powers as are entrusted in terms of the law. In terms of the law.
No.
Yes. Lord,
Injuncted from holding.
no. Lord, perhaps
Please.
Lord, we are not at the,
No.
reading the same paragraphs perhaps.
This court has not. This court says, however, we categorically reaffirm that peaceful protest should not be disturbed or disrupted.
And the state shall not take any precipitate
Precipitate
action against those who are peacefully protesting. Sir, I am not against
these
peace.
documents which you have said, these documents are very categorical. It says that there should not be any violence. The police would remain during the entire, the protest time of a protest. Then all these things are very evident from your own documents.
Lord, I only want, Lord, I said, Lord, when I started my submission, I said, Lord, I am not asking for any stoppage of the protest.
So it is so far as the public order or the law and order is concerned, it is the state's prerogative.
Therefore, Lord, that
So
is
now you have to take adequate measures, because if these peaceful protests are being done, how can you say that it will not be
I am not,
done
Lord,
by
for a moment against the peaceful protest.
True,
Because I
but
myself have
everything
participated
what
in
you
the
are
protest.
saying is that everything is at the bottom line of the entire argument is, though at one say you say that I am not against the protest, and on the second breath you are saying no, there should be something which has to be done. That what does it mean?
Lord, it means, Lord, there has to be a proper regulation so that, Lord, it does not
Now,
affect the
once
public
Supreme
life.
Court, when the Supreme Court has said we have not injuncted, the peaceful protest would come. Let there be a peaceful protest.
Lord, kindly,
It
Lord, only
appears from the record, at least nothing we can decipher. As of now, the record does not reveal anything.
Lord, if the protest,
now it is the police who has to take all the adequate measures.
that is precisely what I want. I want, Lord, the police.
That is your duty. What do you want? Are you reminding them of their duties?
No, Lord, the question is that the last time when the protest happened.
Injunction you have sought for not organizing, prohibition.
No,
there is a absolutely be
kindly see, Lord, my prayer.
Nature of prohibition be issued, prohibiting from rally.
Kindly, Lord, see the end. Since no person organizing comes forward with a proper application seeking permission.
19.2 does not talk about a prohibition. It talk about a reasonable restrictions. There is a complete gulf of difference between a prohibition and a restriction.
Lord, I accept that.
Reasonable.
I accept that. Reasonable restriction is what is interpreted by the Supreme Court. Kindly see my prayer C also. I don't say that you don't completely prohibit. I say that there should be regulated demonstration. Lord, may I just cite one more judgment on this? 2020 volume 10. This is 2020 volume 10 SCC, page 439.
Yes.
Lord, kindly come to paragraph 14.
Yes.
Lord, kindly take the fourth line. One of these rules, kindly, Lord, has your Lordship got
Line
that?
of page, paragraph 14.
14 is
Internal page 6.
one of it. It is
One
after
of these.
one of these rules required prior permission to be taken for a holding of public meetings. The
That is the
Supreme Court,
Bombay Police Act.
yes. Supreme Court opined that the state can only make regulations in aid of the light of the assembly of each citizen and can only impose reasonable restrictions in the interest of public order. With regard to whether or not these rules violated Article 19(1)(b) of the Constitution of India, it was held that while the state cannot impose any unreasonable restriction, a right to hold meetings on public streets was subject to control of the appropriate authority regarding the time and place of the meeting and subject to consideration to public order. However, as the rule requiring prior permission of the authority concerned did not contain any guidance as to when such permission to hold a public meeting may be refused, it was found that the same conferred arbitrary power and gave an unguided discretion to the authority concerned. This was accordingly held to be ultra-vires under 19(1)(b). Then Lord Mazdoor Kishan's case.
So it has gone against you. It was
No,
declared
kindly
be an
come to
ultra-vires.
then Lord, kindly come to 16.
Yes.
Paragraph 16. India, as we know, in today, traces its foundation back to when the seeds of protest during our freedom struggle were sown deep to eventually flower into a democracy. What must be kept in mind, however, is that the erstwhile mode and manner of dissent against colonial rule cannot be equated with dissent in a self-ruled democracy. Our constitution scheme comes with a right to protest and express dissent, but with an obligation towards certain duties. Article 19, one of the cornerstones of the Constitution of India, confers upon its citizens two treasured rights: the right to freedom of speech and expression and right to assemble peacefully without arms under 19(1)(b). These rights in cohesion enable every citizen to assemble peacefully and protest against the actions or inaction of the state. The same must be respected and encouraged by the state, for the strength of democracy such as ours lies in the same. These rights are subject to reasonable restrictions, which inter alia pertain to the interest of the sovereignty of integrity and public order and to regulations by the police authorities concerned in this regard. Additionally, as was discussed in Mazdoor Kisan, each fundamental right, be it of an individual or a class, does not exist in isolation and has to be balanced with every other contrasting right. It was in this respect that in this case, an attempt was made by us to reach a solution where the rights of protesters were to be balanced with that of the commuters. Then Lord, paragraph 17. However, while appreciating the existence of right to peaceful protest against a legislation, etc., we have to make it unequivocally clear that public ways and public spaces cannot be occupied in such a manner, and that too indefinitely. Democracy and dissent go hand in hand. But then the demonstration expressing dissent have to be in designated places alone. The present case was not even one of protest taking place in an undesignated area, but was a blockage of a public way which caused grave inconvenience to commuters. We cannot accept that plea of the applicant. In an indeterminable number of people can assemble wherever they choose to protest. Lord, here the call is that one member from each family has to should participate. Now, Lord,
Yes.
Lord, there are two things. Lord, what principally it says that one fundamental right cannot wash away the other fundamental right. So there has to be a balance. And this is the balancing factor which the police has to do. And Lord, my contention is
here police.
Very well. Lord, there are 4 points that I want to make. May I just formulate my points and then, Lord, I take my seat. My first contention is a right to hold meeting on public street is subject to control of the appropriate authority regarding time and place of the meeting and subject to consideration of public order. So, Lord, this has to be kept in mind while, Lord, permitting, Lord, a demonstration or a peaceful whatever protest. Number 2 is the balancing of interest of residents in the area vis-a-vis the interest of the protesters, limiting the use. That means, Lord, the rights should not, one right should not eat up the other right. There has to be a balancing act. Now, third contention is, Lord, the other factors, that is obstruction to traffic, danger to human safety, and disturbance to public tranquility.
Where you got it?
My Lord?
From where you got it?
It is there in the judgment itself.
No. Sir, the judgment is decided on the basis of a facts involved in the said case. When you talk about this danger, there should be some kind of a materials which you should unearth or disclose in your petition. The Supreme Court in one case has made certain observation. That was an observation.
Come to page
in
12.
connection with the facts of that case.
Come
There
to
may
page
be a
12.
material.
Come to page 12.
Page 12, paragraph.
Please, you have said where is the material for that?
Material is here.
Where?
Because, Lord,
From
they say,
27 onwards, show us the material.
Lord, I have pleaded that, Lord, if
that pleading, I understand
if
you
the procession, Lord,
but there must be some corroborative evidence in
no,
this
if
regard.
the procession takes, Lord, the second Hooghly Bridge, that's the only way go to Navanno. That's the pleading. Your Lordship will see my paragraph 11.
Right.
Therefore, Lord, once this is the main arterial road which connects, Lord, to the highway. So, Lord, if this road gets blocked, then, Lord, the residents can't go back home or come out of their residence. This is an inconvenience which they are going to face.
The another first point which you have read, balancing of both the rights.
That's right.
But you say the danger, safety, security, when
No,
you talk about it.
I say, Lord, disturbance
I'm
to
just talking in that. I reacted to that portion. Not the first portion, I did not react. How to balance the fundamental rights of two individuals, definitely the court will take into will see to it. But
the other aspect is that, Lord, disturbance to public tranquility. In vis-a-vis that, Lord, I said that, Lord, there'll be obstruction on the road, there'll be danger to human safety.
This is what I'm saying. When you talk about a danger to a human safety, that is what I was just thinking. Was there any material? Is there any material in this regard?
Lord, the last three experience, the three Navanno Obhijan's experience, I have narrated in paragraph 11. Your Lordships will kindly see that. My apprehension comes from that. And page 51 is one such report, Lord, which is there. 51 to 60. These are the reports that these are the outcomes.
Happened in previous occasions.
There were serious, Lord, ramifications. And Lord, this is what we are afraid of.
Yes.
This is, Lord, my third point with regard to public tranquility, obstruction to traffic and danger to human safety. Now, Lord, my fourth point is that right to protest is subject to reasonable restrictions.
27 UGC NET examination is there.
What are you talking? This was in relation to some other place, not at the Navanno. It says the Chitpur Mode.
No.
At
Paragraph, page 51.
Yes, look at the photographs and then the bottom. What it says.
No. এই ছবিটা বলছেন। ছবিটা বলছেন যে this is in Chitpur mode. But this is relatable to the Obhijan. And then, Lord, please see the other, Lord, kindly come to page 53.
Sir, again, we cannot go into all these aspects at this stage.
Lord, I am just expressing an apprehension.
There are the judgments which you have cited. There are many things which are held by the Supreme Court.
But Lord,
many things. We do not want to make any comment or do not want to say anything further on that.
Lord, I am not, Lord, for a moment on peaceful demonstration at all. I am saying that these are the ramifications which has happened in the past. The government can designate a place, my lord, where they can go and demonstrate. There is an examination which is also scheduled to be held on the 27th.
What?
UGC NET examination.
Yes. Where is the centers?
No,
Center
center is all around, all around West
Where?
Bengal. Lord, I have said that, your lordships, kindly give me 1 minute. Page 48, if your lordships kindly come to. No, page 48. Oh, that is, no, not that one. Page
10,
Page 10,
para 9.
para 9. Ten. 49 হচ্ছে ওদের post, no, page,
What are you
paragraph
talking?
9, page 10. But in any event, blood, state must be having information. They can provide blood. What are the center? Which are the center where these examinations are
That's
going?
why I said that
Very well,
let us
your
hear the
lordship,
state
hear them. But blood, I say that these
and
there has to be a
is
balancing act.
representing the other respondents. So is only one respondent.
Private respondent, blood, we have only gathered the name of this gentleman. We have
Yes.
made him party. We are
Yes.
Now, my lord, may I assist your lordship, my lord, on behalf of the state? Now, my lord, first is, my lord, the new challenges, my lord, because of, my lord, social media. Here, your lordships have found, my lord, from the writ petition that, my lord, the call for the demonstration is by way of, my lord, social media posts.
Mr. Advocate General, before you further, whether this particular issue was raised before the Supreme Court on the last date of hearing?
My lord, so far as this issue is concerned, my lord, this was not raised before the Honorable Supreme Court, number one. Number two, my lord, if your lordships may kindly have an order of the, orders of the Supreme Court, my lord, the Supreme Court orders were all, my lord, confined to, my lord, the peaceful protest by the doctors and the medical professionals. My lord, to, my lord, dispel the doubts from the mind of the court, my lord, if your lordships may kindly take, my lord, Mr. Bandopadhyay is there, may kindly take, my lord, the two orders which were passed by the Honorable Supreme Court on 20th of August 2024, and then, my lord, the 22nd order, my lord, paragraph 9, which my lords were pleased to, my lord, refer to.
Yes.
But if your lordships are having, my lord, the reportable order of the Supreme Court of 28th, where there are two orders made on 28th, please take, my lord.
Your lordship is having the 22nd. Oh. 20th. But 22nd is there. 20th is not there.
Look, the state is not equipped with all documents.
No, 22nd is there.
Yes.
Your Advocate General is referring 20th.
Yes, 20th orders, Mr. Dinda, I told you to bring those orders.
But,
But in the meantime, may I proceed, my lord? They'll get copies, my lord, immediately, my lord. My lord, may I proceed, my lord, with the other aspects of the matter, my lord? Mr. Bandopadhyay, please get the orders from my office.
Yes. But I'm borrowing one copy from my learned senior in for the time. But I'm having a soft copy also. My lord. My lord, may I hand over a soft copy also?
But, in taking a printout, I have followed the practice of Mr. Shoktinath Mukherjee. Your Lordship, no, the used paper. Your Lordship admonishes me.
No, that's, I appreciate it. I appreciate because at least it saves lot of papers. Yes.
Similar that the first order of 20th of August, which they call a reportable order, please take note paragraph 6 of that order. It starts with nationwide protests.
Yes.
Nationwide protests following the brutal incident in Arjikar Medical College Hospital have brought the issue of lack of institutional safety for the doctors to the forefront. Medical associations have consistently raised issues of lack of workplace safety in healthcare institutions. Medical professionals in the performance of their duties have been unfortunate targets of various forms of violence. Hospitals and medical care facilities are open throughout the day and night. Medical professionals, doctors, so and so work round the clock. Unrestricted access to every part of the healthcare institutions has made the healthcare professionals susceptible to violence. Patients or relatives in anguish are quick to attribute untoward results to the negligence of medical professionals. Such allegations are immediately followed by violence against the medical professionals. In May 2024, two on-duty doctors were allegedly attacked by relatives of a patient who died during treatment in a hospital in West Bengal. In another incident in May 24 in Bihar, following the death of a 25-year-old pregnant patient, a nurse was allegedly pushed off the first floor of the building by the kin of the patient. In August 2024, a finally a resident in a hospital in Hyderabad was allegedly assaulted by the patient's attendants after the patient died due to medical conditions. These incidents of violence are a few amongst the many that have been unleashed against members of the medical community in the recent past. They are portents of a system failure to protect doctors, nurses, and paramedical staff in the confines of the hospital with few or no protective systems to ensure their safety. Medical professionals have become vulnerable to violence. With the involvement of systematic issues for healthcare across the nation, this court has had to intervene. Now, this is the background. Now, Milord, please kindly consider, Milord, paragraph number. The next paragraph is paragraph 7. But if I may skip over to Milord, about 10 lines, Milord, from the bottom of paragraph 7 in the next page, which starts like, while gendered violence. Well, it's in next page possibly. Next page, line number 5. While my lords are found, Milord.
Yes.
While gendered violence is the source of malevolent manifestations of the structural deficiencies in public health institutions, the lack of safety is of concern to all medical professionals. Preserving safe conditions, etc., is essential to realizing equal opportunity or to every working professional. This is not just a matter of protecting doctors. Their safety and well-being as health providers is a matter of national interest. As more and more women join the workforce in cutting-edge areas of knowledge and science, the nation has a vital stake in ensuring safe and dignified conditions of work. The constitutional value of equality demands nothing else and will not brook the compromises on the health, well-being, and safety of those who provide healthcare to others. Therefore, Milord, everything is confined in my very respectful submission for Milord, the medical professionals. Now, kindly take note, paragraph number 9. We have attempted to flag here the ground realities, indicating the lack of institutional safety standards in healthcare establishments. A non-exhaustive formulation is set out below. Milord, I don't think that I need to trouble your lordship with the rest of it. Then, Milord, a national task force has been constituted. Now, kindly take note the other order of 20th of August, which they call record of proceedings.
না না দুটো একটা সেট দুটো একটা সেট
আরে ভাই
Yes.
now please take me look the second page, paragraph number 2. We expect that the government of West Bengal shall observe necessary restraint in the face of the peaceful protest conducted by any quarter of civil society bearing on the issue which forms the subject matter of the incident which took place at Kolkata. It shall be ensured that the power of the state is not unleashed on peaceful protesters. Then, my lord, the other directions are there. Therefore, my lord, what I very respectfully submit is this paragraph 2 of the record of proceedings, in my very respectful submission, my lord, will not, my lord, cover Milord, the other things which are not the subject matter of the main proceedings or the Milord suo motu cognizance which the Honorable Supreme Court has taken only for the purpose of ensuring Milord protection to the medical workers. Whatever agitation had flown from Milord through the medical professionals like the junior doctors, etc., nurses, others, Milord, which have erupted Milord from the unfortunate incident, etc. Now, please take Milord yesterday's order, which is 22nd of August.
So according to you, this paragraph 2 has to be read only in relation to a medical doctors or the medical staff.
Yes.
And therefore, it is only the persons who are related to these medical institutions.
Right.
The protest, no other person can hold the protest. That is what you want.
But the only with this clarification, the Supreme Court was not considering Milord the protests by the other members.
What is the word? What is the meaning of the word civil society, which is used in paragraph 2?
Yes.
What does it indicate?
Yes. Now, Milord, yes, coupled with that, yes, very well. But I for the Milord present Milord presume that Milord the expression includes Milord every member of the society from all walks of life. Yes. For the time being, Milord, I presume that. Now, please, Milord, take Milord yesterday's order, paragraph number 9.
Yes. Yes, sir.
Mr. Kapil Sibal, Senior Counsel appearing on behalf of the State of West Bengal and Kolkata Police submits that while this court has permitted peaceful protests, now this permission of peaceful protests against Milord is confined to the medical professionals. But for the time being, I include everybody else also. For the time being, kindly take note after the comma. The order should not be misconstrued to mean that the authorities are precluded from exercising their regulatory powers in accordance with law. This court has not injuncted the state from exercising such lawful powers as are entrusted in terms of the law. However, we categorically reaffirm that peaceful protest should not be disturbed or disrupted, and the state shall not take any precipitate action against those who are peacefully protesting against the incident which took place at so-and-so. Now, my lord, presuming for argument's sake, my lord, for the present that it includes all sections of the civil society, my lord, the Supreme Court has said that the state's regulatory power is not injuncted by the Supreme Court. Now, what are the regulatory powers? Please take, my lord, the Police Act 1861. My learned juniors may have copies of that. These are, my lord, the new challenges, my lord, because of, my lord, development of the information technology.
Yes.
Please take, my lord, section 30. What are, my lord, the duties of the police?
Yes.
Regulation of public assemblies and processions and licensing of the same. The district superintendent or assistant district superintendent of police may, as occasion requires, direct of all assemblies and processions on the public roads or in the public streets or thoroughfares and prescribe the routes by which and times at such such processions may pass. So this is mere one of my regulatory powers. Now, how this is exercised, please take mere subsection 2. He may also, on being satisfied that it is intended by any person or class of persons to convene or collect an assembly in any such road, street, or thoroughfare, or to form a procession, which would, in the judgment of the magistrate of the district or of the subdivision of a district, if uncontrolled, be likely to cause a breach of the peace, required by general or special notice, that the persons convening or collecting such assembly or directing or promoting such procession shall apply for a license. So I can direct them to apply for a license. Then, on such application being made, he may issue a license specifying the name of the licensees and defining the conditions on which alone such as assembly or such procession is to be permitted to take place, or otherwise giving effect to this section, provided that no fee shall be charged. Therefore, my lord, these are my regulatory powers. Now kindly take me to the next section, that is section 30, capital A, where there is a consequence for violation also. Any magistrate or district superintendent of police or so and so, so and so, so and so may stop any procession which violates the conditions of a license granted under the last foregoing section, and may order it or any assembly which violates such conditions as aforesaid to disperse. Any procession or assembly which neglects or refuses to obey the order under given under the last preceding subsection shall be deemed to be an unlawful assembly. Then police to keep order, that is section 31, it shall be the duty of the police to etc. When I skip over 31, please take 32. 31 is also important, but since I am only on regulatory powers, I skip over 31 for the time being. 32 is penalty for disobeying orders issued under the last three sections. Every person opposing or not obeying the orders issued under the last three preceding sections, or violating the conditions of any license granted by so and so, for so and so, or for the conduct of assemblies and procession, shall be liable for conviction before a magistrate to a fine not exceeding, etc. Now, my lord, these are, my lord, my regulatory powers. Now, coupled with this, my lord, please take, my lord, the police regulation of Bengal. Since, my lord, we are, my lord, in the district of Howrah, therefore kindly take, my lord. Mr. Bandopadhyay, kindly hand up the police regulations of Bengal.
Yes.
Please find out regulation 135.
135. D নাই বার করে দিচ্ছি।
এটা বার করো।
Yes.
My lord, regulation 135, issue of notices under section 32 of the Police Act. If any superintendent considers it is necessary to call upon any person or class of persons under 32 of the Police Act to apply for a license in respect of any assembly or procession, he shall obtain from the district or the subdivision magistrate a statement in writing that in the judgment of the said magistrate, the assembly or procession is likely to be held during a certain period and uncontrolled to cause breach of peace. He may cause a general or special notice in DP form number so and so to be issued directing such and such. Then 3 says he shall specify in such notice the length of the period during which a license shall be necessary for such assembly or procession if the notice is intended to cover more than a particular occasion. Then where 136 is form of the license. The license is to be issued in under section 33 of the Police Act in form number, etc. Then 137 is directions under 31 of the Police Act Under Section 31 of the Police Act, the superintendent will issue directions regarding to the conduct of the assembly, whether it is licensed or not, and whether there has been a notice requiring on any application requesting a license or not. Unless he proposes to take action under Regulation 134, he should issue such directions whenever any persons give notice of his intention to convene or collect any assembly or to direct, promote, etc. Then with the procedures are laid down. Then we are 138 is the matters which are to be included in the licenses and directions. 139, it should be in triplicate, etc. Then disobedience is 140. This is basically recoining the provisions of the Police Act 1861 through regulations 135 to 140.
Yes.
At the end of that book, your lordships will find the forms, necessary forms, under which these are to be made. Kindly take just after the police regulation ends. But I cannot give you lordships the page number. The regulation ends at regulation 1290. Just after that, after regulation 1290, the forms are there. But in fact, that is volume 2, but both the volumes has been combined in one in all books.
No, after 1290, nothing. Then the appendix comes.
Yes.
Service conduct.
Then it comes with the West Bengal Government Servants Conduct Rules, 1959.
Oh, I'm sorry, Then do your lordships have this book by D.K. Ganguly, the green one?
No, it's by Robin Bhattacharya.
Oh. But I can send across these are the specific forms where I immediately take snaps of it and transmit it to Mr. Bandopadhyay so that he can take a printout and hand up to the court. These are statutory forms. Therefore, first is my first respectful submission is assuming for argument's sake for the present that the Supreme Court orders extends to all members of the civil society, then also the Supreme Court has said that our regulatory or the state's regulatory power is not interfered with by this honorable court, by the honorable Supreme Court. The regulatory powers are twofold in nature. The first nature of the regulatory powers are the provisions which I have already placed before my lord. But the second form of regulatory powers are under Article 19, read with Section 144 and the present Section 163 of the BNSS. But this is the second form of regulatory powers that the state enjoys in respect of the processions or public assemblies. Or in other words, what is the challenge today? Where the challenge today is that an unknown group of people, nobody taking responsibility, nobody taking leadership, have called for a march on the 27th to Navanna. Please consider whether these kinds of social media calls come within the four corners of the Police Act as well as the Police Regulation Bengal. Similar provisions are there in Police Regulation Calcutta as well, but I don't trouble you a lot with those for the present. Therefore, whether the fundamental question which that is why yesterday while mentioning I requested that the other matters if could be brought before this court. Anyway, that whether this kind of a call is at all permissible or contemplated and comprehended under the present legal system or the laws that operate in our country today. But in my very respectful submission, unless somebody applies or unless, my lord, some determinate class of person. My lord, your lordship has seen, my lord, Mr. Kaur has shown, I don't waste your lordship's judicial time, that from each family one person should come. Whether, my lord, in the backdrop of these kinds of, my lord, protest calls, my lord, these provisions can be made workable. But I need not tell your lordship, my lord, that, my lord, there cannot be any, my lord, interpretation which, my lord, makes the law unworkable. And, my lord, at the same time, my lord, your lordships have noticed that these sections of the Police Act are, my lord, both regulatory as well as penal in nature, because they provide for conviction in a case where, my lord, the conditions of the licenses are contravened. Therefore, my lord, I very respectfully submit, my lord, that unless, my lord, there are specific applications, my lord, I cannot exercise my regulatory powers, which, my lord, the Honorable Supreme Court has also been pleased to, my lord, observe in paragraph 9 of yesterday's orders. But this is, my lord, my first limb of submission. Well, my second limb of submission would be, my lord, that, my lord, there are orders, my lord, which have been issued long time back under section 144, which are still continuing and, my lord, extended from time to time, where, my lord, this Novanno and its adjoining areas have been declared to be high security zones, and, my lord, no processions, or, my lord, as your lordship knows, my lord, assembly. Yes.
Apart from Navanno, is there any other place where there has been a very sensitive zone?
My lord, in fact, my lord, your lordship will find that in and around Novanno, yes, I'm sorry.
Can you say any other places which is a very sensitive area and there is already an order which is operating?
My lord, we can speak of, my lord, the Raj Bhavan beside our High Court building.
There was a demonstration. Was it within the permissible regulatory limits?
My lord, that is, my lord, under consideration before another bench of this honorable court, my lord, whether, my lord, that could have been allowed or not. And, my lord, this honorable court, my lord, has been pleased to, my lord, keep the matter pending. But on that, my lord, if your lordship, my lord, permits me, my lord, I can also address your lordship, my lord, that in a case there is a breach of 144, what is the consequences or what is the procedure?
That is not an issue.
Yes, exactly. Therefore, my lord, this was my first point. Now, kindly take, my lord, my second point. Second point is, my lord, 144 has been imposed.
What do you take? So for that I reacted. Anyhow, then third
Okay.
point.
Third point is, my lord, there is no dispute that, my lord, these are all, my lord, public premises. My lord, Supreme Court in 1969 have, my lord, said that there is no right to hold any demonstration in public premises. You cannot claim it as a matter of right. You can seek permission. This is my understanding. You can seek permission. Police may regulate, police or the state or whoever may regulate. But, my lord, this, nobody can claim it as a matter of right. Now, please take note one judgment. It's a very old judgment, 1969, Volume 1, Supreme Court Cases, page 502. But this was a case, my lord, where, my lord, the railway workers, my lord, they had, my lord, certain grievances against the railway authorities. Therefore, they wanted to demonstrate in railway premises. Please take note paragraph number 10. Or paragraph number 9, my lord, for the to get the glimpse of the facts. The direction with which we are concerned in this appeal is that which prohibits the holding of meetings within the railway premises, including open grounds forming part of those premises. That direction does not deprive the workers of any of the freedoms guaranteed under Article 19(1). It merely prohibits them from exercising any of them within the railway premises. What is prohibited is the holding of meetings for any purpose within the railway premises. The question is whether such a direction is violative of Article 19(1). In the instant case, we are concerned with the meetings. With the meetings held outside the main time office and it was not denied that the place formed part of the railway premises. It was strenuously urged on behalf of the respondent that the rights guaranteed under Articles 91 A, B, and C are inviolable and they cannot be interfered with excepting in accordance with clauses 2, 3, and 4 of the said article. According to Mr. Garg, the railway workers have a right to assemble in any place they choose and give expression or to their views so long as they do not disturb the work going on the premises and that the right is guaranteed to them under the Constitution. Now, paragraph 11 is the one which I intend to lay emphasis. It was not disputed that the Northern Railway is the owner of the premises in question. The fact that the Indian Railways are state undertakings does not affect their right to enjoy their properties in the same manner as any private individual may do, subject only to such restrictions as the law or the usage may place on them. Hence, unless it is shown that either under law or because of some usage, the railway servants have a right to hold their meetings in railway premises, we see no basis for objecting to the directions given by the general manager. There is no, the next sentence is where I lay emphasis. There is no fundamental right for anyone to hold meetings in government premises. If it is otherwise, there is bound to be chaos in our offices. The fact that those who work in public offices can go, etc. Then, Millard, paragraph 12. It is true that freedoms guaranteed under the constitutions are very valuable freedoms, and this court would resist abridging the ambit of those freedoms except to the extent permitted by the constitution. The fact that citizens of this country have freedom of speech, freedom to assemble peaceably, and freedom to form association or union does not mean that they can exercise those freedoms in whatever place they please. But this is very important. The exercise of those freedoms will come to an end as soon as the right of someone else to hold his property intervenes. Such a limitation is inherent in exercise of those rights. The validity of the limitation is to be judged by the tests in clauses 2 and 3 of Article 19. In other words, the contents of the freedoms guaranteed by subclauses A, B, and C, the only freedoms with which we are concerned this is appeal, do not include the right to exercise them in properties belonging to others. If Mr. Garg is right in his submissions, then a citizen of this country in exercise of his right under subclauses D and E of Article 19(1) could move about freely in a public office or even reside there unless there exists some law imposing reasonable restrictions on exercise, etc. Therefore, Millard, the fundamental principle that Millard this court, this judgment holds.
Yes. Yes.
So, Millard, the rights under Article 19, Millard, is not unrestricted. The rights are regulatory in nature. And Millard, more specifically, Millard, this right does not encompass that Millard, any citizen can point out any place and say that I have a right to hold the assembly or procession over there.
Yes. I think
Millard,
that's
this is the second part of my submission. The third part, Millard, your Lordship may kindly only note down the judgments because since I've said that 144 is imposed over there, Millard, the Supreme Court has held in innumerable judgments that 144 is a reasonable restrictions contemplated, Millard, by Article 19, 2 and 3, where the oldest one is, Millard, Babulal Parathe, AIR 1961, Supreme Court.
yes.
884.
Page
884. AIR 1961, Supreme Court, page 884. Where one paragraph is sufficient, paragraph 33.
Yes.
We have therefore reached the conclusion that the order of the district magistrate is not unconstitutional either because section 144 itself violates, it's a violative of our fundamental rights recognized in Article 19, or on the ground that it is vague and places that is made in the facts of that case. So this has been reiterated made in Ramlila Maidan also, Milord.
2005
2012 5 SCC page 1. But kindly note down the paragraph numbers, paragraph 43 and 278.
43
and 278.
Yes.
But only one sentence where I would like to, your Lordship need not trouble you, Lordship, same thing with what Babulal Parakhe has said. One sentence from para 60, kindly have a look, Milord. 60 of Ramlila Maidan. But page, para 60 is at Milord printed page 46.
Yes, we have gone through it.
So kindly take the last 4 lines in printed page 46. An order under section 144 would have an application to an actual unlawful assembly as well as a potential unlawful assembly. This is precisely the scope and application and enforcement of etc.
Yes.
Therefore, why I rely upon this sentence from para 60, because today, Milord, there is no application before the police.
Correct.
Today, Milord, I cannot exercise my regulatory powers. Today, Milord, any formation would become an unlawful assembly in view of Milord section 33 of the Milord Police Act. Therefore, Milord, my section 144 orders would also include Milord the unlawful assembly, Milord, which would operate or become an unlawful assembly, Milord, by operation of Milord the Police Act 1861 on 27th of August. Milord, these are Milord my primary Milord threefold submission. Now, Milord, on facts, Milord, just one or two things, Milord. On facts, one or two things. Milord, Mr. Bandopadhyay has Milord already, I'm sorry, Mr. Kaur has already Milord brought to your Lordship's notice. What is very important is, Milord, on that day, Milord, apart from Milord, that it is a high security zone, apart from that, where it will, Milord, proceed on Milord, the main National Highway 117. Milord, apart from the fact that the main thoroughfare will be blocked, what is of most importance is, Milord, that the UGC net examination is to be held on that day. And Milord, the UGC examinations are held throughout the country. And Milord, the examination centers, Milord, as per the notification, Milord, has to be downloaded, Milord, from the website of that National Testing Agency. There are schools, colleges, university, hospitals, everything on that road.
Yes.
Therefore, what is very important, Milord, for this matter is that whether these kinds of calls through social media can be made or not, and if it is allowed, whether, Milord, the provisions of sections of the Police Act, Milord, can be applied or not. But this, I think, Milord, would be of Milord, fundamental importance, Milord, for your Lordships to decide in this matter.
Yes, thank you. Thank
I'm
you.
grateful, Milord. I'm grateful.
But one factor, Lord, kindly take it.
It's not an adversarial litigation
No, not at all. Not at all.
these are
No,
practically
I'm just saying, Lord, that Lord, there is no Lord responsible person who can Lord be held responsible.
Let us see
if things go wrong.
We are keeping those books. We are passing an order.
I'm Lord.
But I'll ensure, Milord, that these forms of licenses, Milord, are given to the court within the next 15 minutes. Milord.
No, ওনারটা আলাদা করে রাখো।
Before your lord.
We will be sitting again for the verdict to be delivered today itself.
Your lordship rises, my lord. I cannot, please pardon me for disturbing your lordship, my lord. Just now, my lord.
Don't absolutely appreciate disturbance actually. If you are raising a grievance, we can there to see
15 minutes ago, my lord, a judgment has been delivered by the Honorable Single Judge, whereby, my lord, an inquiry by the Central Bureau of Investigation has been allowed in respect of a person, my lord, who wanted to intervene in the proceedings by filing an application. He was not impeded. This bench, my lord, bench of justice, Honorable the Chief Justice. My lord, appeal against that order, my lord. Kindly, my lord, I'm preparing the memo of appeal, my lord. Kindly grant us leave, my lord. We want to move it today.
Can't be done in this way.
My lord, 10 a.m. tomorrow morning, my lord, entire case diary has been directed to be handed over and investigation has been directed. Without even hearing us, my lord, we wanted to intervene. My lord, it is against, my lord, I do not want to, my lord, whoever the litigant is, my lord, he should be at least, my lord, elementary, my lord, he should have been heard. And, my lord, may I come back, my lord?
You have nothing, you have not nothing.
My lord,
in your hand.
since the learned advocate general is appearing online, he may not have notice of this, my lord. Kindly takes notice of the third page, my lord. I only intend to point out with a very recent event, he may not have a copy of it, my lord. Third line.
Yes.
I've sent him a copy online, my lord. He might not, he was arguing, my lord.
No, this has been circulated to.
Yes,
to
I only
everybody.
My
pointed.
lord, the leave, my lord, kindly. My lord, kind. My lord, I am getting the copies, my lord, it is just 10. Very well. Very well.
पूछे तो